Today we're going to be talking about a number of topics, but I want to start by framing our conversation in terms of the 14th Amendment, which has been in the news recently for reasons that I think would have surprised most law professors just a few years ago, namely the potential disqualification of Donald Trump from being president. That's in Section 3, a provision that most people don't usually think about. We're going to be thinking about Section 1 of the 14th Amendment. The guarantees that arise out of the Civil War, guarantees against the states. I want to say a very little bit about racial classifications and then get into what is considered to be the most important treatment of gender classifications under the Constitution today. And so some of the big picture questions that I want us to grapple with are those last two there. How do we realize the promise of equality in the Equal Protection Clause? And who decides? That's very often one of the most important questions in public law, that is to say, in litigation involving the government. Who decides these major questions? Do we entrust courts to decide them? Do we think that we, the people, are supposed to decide them? And who counts as we, the people? These are the big picture questions that often occupy us in constitutional law and similar courses. So the 14th Amendment arises in the aftermath of the Civil War. We get this suite of amendments often known as the Civil War Amendments or the Reconstruction Amendments. The 13th Amendment very famously abolishes slavery. The 15th Amendment is going to ensure that voting is not going to be subject to discrimination based on race. The 14th Amendment, though, is the one that gets the most attention. And I want to take just a couple of minutes to spend some time with the text here. This is all really important. Now, the bold-faced portion is what we're really going to be grappling with as we think about the United States versus Virginia. This promise that no state shall make or enforce any law which, in addition to not allowing states to abridge privileges or immunities, to deprive people of life, liberty, or property without due process, it says that states are not allowed to deny to any person within its jurisdiction the equal protection of the laws. Now, this is really interesting because in the original Constitution, there are provisions guaranteeing that there are privileges and immunities that citizens of the United States enjoy. That's in Article 4. There is also in the Bill of Rights, in the Fifth Amendment, a guarantee of due process. But again, that is going to be vis-a-vis the federal government. So we see here the emphasis on no state. Why is it that the 14th Amendment, arising in the aftermath of the Civil War, is focused on what states are allowed to do and what they're not allowed to do? And as I say, be bold, don't be hesitant. Why the emphasis on states?
Because the states were sort of arguing that they're not beholden to those same laws in the Constitution because it was originally meant to restrict the federal government, not the states themselves.
That's exactly right. And so in the 19th century, we see cases coming out in which the Supreme Court says exactly that. The Bill of Rights is a protection against the federal government, and this made sense in the 18th century, when states very much viewed themselves almost as independent countries. There was this fear of this behemoth, this new national government. And so it made sense that the Bill of Rights was a protection against national governmental action against individuals. Okay, so states said that they were not beholden to that. Which states are we particularly concerned about in the immediate aftermath of the Civil War? Southern states overwhelmingly, exactly. And the fear there is that southern states, if left to their own devices, are going to remain totally unreconstructed. And that southern states, through hook and crook, are essentially going to try to use the levers of power to recreate slavery in all but name. And so we have this patchwork of constitutional provisions, we have this patchwork of statutory provisions that the Reconstruction Congress passes to try to avoid that scenario. I want to come back to this highlighted language about the Equal Protection Clause. We don't have a similar provision in the original Constitution. So this is a part of the Constitution that is brand new, this promise of equality, and more specifically, this promise that states are not allowed to deny people the equal protection of the laws. All right, just to stay current, I feel like I need to give you a slide on Section 3. This is a bit of an aside, but we're living within the 14th Amendment, and it is part of that same patchwork that I was talking about to try to prevent former Confederates from getting back into power. So I've tried to bold the provisions that were at issue in the case that the Supreme Court just decided, saying that Colorado is not allowed to prevent President Trump from being on the ballot. So the argument here is that no person shall hold any office, civil or military, under the United States who, having previously taken an oath as an officer of the United States to support the Constitution, shall have engaged in insurrection or rebellion against the same. Again, we can appreciate how in the aftermath of the Civil War, this was doing real work. It was doing real work in preventing Confederates from being able to get back into power. So you've got the substantive promises of Section 1. You've got Section 3 almost as the structural protection to prevent disloyal people from getting back into power. And then what I don't have up here is Section 5, which empowers Congress to enforce all of these provisions. So again, they're working together. This is the one that, again, involves President Trump. I'm going to leave that aside and bring us back to those substantive provisions and equal protection and the way that that has cashed out. Now, in the late 19th century, the Supreme Court essentially pulled back from this promise. And we're going to see that that is going to have ramifications for decades and decades. There is the infamous case at this point of Plessy versus Ferguson, which said essentially that equality can be guaranteed even if there are racial classifications, and that's infamously encapsulated in this phrase, separate but equal. And the Supreme Court essentially said, shame on you if you think that a separation of races implies any sort of inequality. It does not necessarily imply the inferiority of either race to the other. Now, we shouldn't believe a word of that, and we don't today. By the way, this is the spot in New Orleans. Yeah, you can still go there today. There's a wonderful plaque that commemorates where Homer Plessy was arrested. It was essentially a contrived lawsuit because New Orleans was, at least for the time, a very racially progressive area. And so the idea was to get Homer Plessy's test case all the way up to the Supreme Court to figure out exactly what the 14th Amendment meant. So you've got a changing mural there, a great plaque, as I mentioned. So next time you're in New Orleans, get down to the intersection of Royal and Press Street. It's a moment that you will hold with you. All right, so racial classifications, according to the Supreme Court, are appropriate as long as the promise of equality is there. Now, this changes by the middle of the 20th century. In the middle of the Civil Rights era, the Supreme Court very famously decides the case of Brown versus Board of Education. And it says, by the way, Plessy versus Ferguson, the racial classification was with respect to public transportation. Now, we tend to think of these classifications as being odious regardless of the context, but through the late 19th and early 20th centuries, context mattered. And it's something that I definitely spend time in my actual constitutional law class on why it is that public education was considered such a third rail for Southern white people. All right, but I want to leave that aside for the moment. In the sphere of public education, the doctrine of separate but equal, the Supreme Court said, has no place. All right, so why could separate not be equal? And I want to complicate this a little bit by pointing out that there were 5 school districts that were involved in the Brown versus Board of Education litigation. The one involving Topeka, Kansas, where Linda Brown was the lead plaintiff, was in some ways the hardest for the Supreme Court. The Topeka High School was already integrated, And Linda Brown was attending a segregated elementary school, but one that was very, very nearly on par in terms of funding and facilities with white schools. So a huge part of the problem that litigators had focused on was that the promise of separate but equal had gone unfulfilled. There was at least a chance that Topeka, Kansas was on the cusp of fulfilling that promise of equality, even amidst separation. So why, even in Linda Brown's case, was separate but equal a problem? Go ahead.
Could it have something to do with like the prestige of the school, right? Where you'll see one that's not so good, but you see that white school maybe better.
Right. Right. So there might be a perception, even if the funding is equal, the quality of education is the same, so on and so forth. So yeah, what else?
Could it potentially be like outcomes from the school, like what local, I guess, businesses employ from?
Okay. So outcomes in terms of, I think, tying into this idea of prestige and perception.
Was it distance? The school was further away and she had the other school was in the proper boundaries or something of the sort?
Okay, I think that you could make that argument. The Supreme Court ultimately does not. It makes this fairly sweeping statement that separate but equal has no place, essentially, even if you have a school that has equal funding, has equal outcomes, so on and so forth. What is still the problem? What is the problem? Go ahead.
I think the problem is when you're in separate schools, you're kind of isolated from other groups and other viewpoints, so it's not equal because you're not able to engage with those ideas.
Okay, so that is very much a part of how the Supreme Court has understood this notion of separate but equal, why it has been rejected, and why in even the 21st century, we need to be attuned to the idea of diverse perspectives. That was the underpinning of affirmative action jurisprudence for the better part of 50 years. That we simply are not going to have a complete engagement with the world if we are living in these totally separate spheres. Let me go back to this statement from Plessy versus Ferguson, which I said we shouldn't buy. That laws requiring segregation do not necessarily imply the inferiority of either race to the other. Why is that not true? In the context of racial classifications, why is there this badge of inferiority, to use the Supreme Court's terminology, in separation, even if outcomes and funding and all of that are the same?
It's like implicit in the act of separation itself, because like you wouldn't need to separate the two groups if they were equal.
Okay, so it is a governmental action conveying a sense that black people are not equal to white people. And even if you're providing equal funding, pristine schools, educational outcomes are the same in terms of test scores, whatever it is, that governmental action, that motivation behind what the government did is going to be an enormous problem. And there is almost no amount of money that is going to cure that. And it's why the NAACP stopped taking lawsuits that were going to fight only for equal funding. They said, essentially, there's no amount of equal funding that is going to be able to dispel this quote-unquote badge of inferiority that the government has imposed on people. And so that is why the Supreme Court in Brown versus Board of Education essentially says, I don't care about funding. I don't care about any of that. Separate but equal, oh, no, wrong slide. Separate but equal simply has no place. The doctrine has no place, at least in the context of public education, and then very shortly afterward, the Supreme Court is going to say much the same thing in all sorts of other contexts, including swimming pools, public transportation, you name it. Okay, so let's bring that forward to the middle to the late 20th century and think about how this applies, if at all, or perhaps slightly differently, to gender classifications. Notice, by the way, that Section 1 of the 14th Amendment, with its promise of the equal protection of the laws, makes no mention of race. There's no explicit mention of race. hold on to that for a second. Want to talk about VMI, which on a clearer day, you could actually see through that window too. Yeah, you can see just the tip of the roof over there of one of the buildings. So our next door neighbor over here. So tell me about the Virginia Military Institute. When was it founded, and what is unique about it? Founded in 1839. And what is distinctive about VMI compared to almost any, well, let me start with public or private institution. Go ahead.
It's a public institute for men.
So yes, at the time of the litigation, public institution for men remains public. We'll talk about the aftermath of the decision. VMI had a choice. If it was going to remain all male, it essentially had to stop being a public institution. It could have gone private. The Board of Trustees, I forget exactly what the governing body is called, but the board took a vote, and the vote was 5-4. By one vote, VMI decided to stay a public institution, and in doing so, they committed to admitting women at that point on an equal basis with men. Okay, so VMI is founded in the early 19th century. Up until the decision of this case, it was an all-male institution. What else about it? What is unique about VMI?
It educates based on the adversarial model. So it presents freshmen with adversity, and then it believes that they'll bond through sharing that adversity.
Okay, so what they call the adversative method. Exactly right, which is that this is hard. It is physically hard. It is mentally hard. And so, yes, cadets are very much aware of what they are signing up for when they go to VMI. It is very different than the college experience that most of us had. All right, so why is it thought that that entire experience and then the years after graduation are going to confer unique benefits on VMI students and graduates?
There was a thought that it sort of bonded the students together, both the people in the same class because they went through it all at the same time, and also the people in the higher classes because they went through it before them.
That's exactly right. And it turns out that it is one of the most tight-knit, engaged alumni networks in the entire country. Okay, so this is something that Justice Ginsburg is talking about in the majority opinion, that there are these benefits that come not just from the degree itself, but from these networking opportunities that will reap benefits for an entire lifetime in many instances. All right, so VMI admits only men. And what is its justification for why it should remain an all-male institution? And it's got a number of arguments. And Justice Scalia, I think, spends a fair amount of time in his dissent talking about them. What are some of the reasons why, in his view, VMI should have remained all-male, or at least had the option to do so?
It contributes to the diversity of schools.
Okay, so it contributes to the diversity of public institutions in Virginia. Virginia has a huge array of public institutions of higher learning, and it caters to all sorts of different students and different needs. There are world-class research institutions. There are public liberal arts colleges. There are two-year community colleges. There are all sorts of different experiences, and not every single one of them is right for every single person. So I will tell you very honestly, I was not suited to the adversative method at VMI. So it would not have behooved me to apply to VMI when I was a senior in high school. It wasn't right for me. It's not right for a lot of people, says Justice Scalia. But that's okay, because Virginia has a really wide array of opportunities, and there will be something that will be right for you if you are a Virginian and you want to attend a public institution. All right, so this diversity rationale. Virginia has this diversity of public institutions, and they don't all have to be the same. They can offer different opportunities to different people. All right, great. What else?
The curriculum, without being modified, is unsuitable for women, and if it was modified,
okay, so this idea that what is so unique about VMI in the actual experience, particularly during the first year, is this adversative method, this intense physical, mental exertion and these challenges that the cadets face. And Justice Scalia says, well, if you take that away in order to accommodate women, then it's basically not VMI anymore. And I mean, maybe that's the right conclusion, says Justice Scalia, but probably not. I mean, this is a venerable institution, and so, you know, you should be able, if you're VMI, to preserve what makes VMI VMI. What does Justice Ginsburg say about that second rationale? That you'd just be taking away VMI as we know it. Go ahead.
Is it that women are capable of kind of like dealing with the curriculum as evidenced by the fact that they participated in the other armed forces and other federal military academies?
Yeah, so the service institutions like West Point had long since admitted women, and there was zero evidence that it was compromising the ability of the service academies to discharge their responsibilities. It had not had a deleterious effect on the education provided there. So the facts don't support that. All right, this comes back to one of the major questions that I posed at the beginning. Who decides? Who decides this question about whether Virginia's stated rationale at this point in the litigation of creating this panoply of options in public education for Virginia students is going to allow for VMI to exist as an all-male institution? Who decides? Is it the federal government? Notice the United States is suing Virginia, saying you have violated the Equal Protection Clause. So is it the federal government through our political actors? Is it the Supreme Court? Is it the people of Virginia? Who gets to decide that question? And I'm really phrasing that as a question of who should decide that question. Go ahead.
I mean, isn't that still up for debate today?
It is. It is still very much up for debate today. We live with that constantly because in some ways we think of courts as these neutral arbiters, not necessarily subject to majoritarian or electoral pressures, just sticking their fingers in the wind to see what 51% of people want. We think of courts as being there to protect minority rights within a majoritarian system. At the same time, those opening words of the Constitution refer to we the people, this idea of popular sovereignty, the idea that we decide what exactly we want the Constitution to mean. And arguably that is especially true when we're dealing with these promises that are phrased at super, super high levels of abstraction, like the equal protection of the laws, due process of law. That's not super specific. That is what some scholars and judges will call an open-textured provision. Chief Justice Roberts, who is known as a fairly conservative jurist, during his confirmation hearing said there's an enormous difference between a constitutional provision that is very specific, for instance, the requirement that you have to be at least 35 years old to be president of the United States, and something that is as open-textured as the Equal Protection Clause. And so arguably, we the people, through our elected representatives, have a whole lot more latitude to fill in the gaps, to liquidate those kind of provisions, as some people will put it. All right, so I phrased that as one of those unanswerable questions that will continue to bedevil us for as long as the United States still exists. So I want to phrase or pose these questions. Number one, can separate ever be equal? We saw in the racial discrimination context that the Supreme Court's answer is an emphatic no. And a huge part of that owes to the history of the United States. the idea that because racial classifications were so invidious, were born of the rank bias, that there is almost no way that separate could be equal when we are talking about racial classifications. Now, Justice Ginsburg is similarly concerned with this quote-unquote badge of inferiority if you were to have single-sex education at VMI. By the way, when she was a law professor, she was very actively engaged in litigating cases that came to use the Equal Protection Clause as a font of guaranteeing gender equality. And so through the 1970s, you see Justice Ginsburg as an advocate in the Supreme Court arguing that the Equal Protection Clause essentially prohibits gender stereotyping. Now, in the opinion itself, she acknowledges, look, there are inherent biological differences between men and women, and it is totally fine for the law to take account of those actual differences. But what the Constitution does not allow, she says, is for differences that are based only on stereotypes. Women stay at home. Women take care of the children. Women aren't as capable in XYZ spheres. That sort of stereotyping cannot be a basis for any sort of gender classification. All right, so let's just think about instances where we think that gender classifications are fine. That is to say, where they are not going to necessarily reflect this stereotyping of a bygone era, but where differentiation is still going to be consistent with the promise of equality. Can we think of situations like that?
Men and women's bathrooms.
Right, men and women's bathrooms. And that's not to say that we have to have a distinction between men and women's bathrooms. We can have gender-neutral bathrooms if we want to. But the question is, if a public institution has separate men's and women's bathrooms, is that inherently conveying that women are inferior to men? I think most people would say probably not. So, yeah, if separate bathroom facilities don't necessarily connote this governmental vision of inferiority, then perhaps separate sometimes can be equal. Can we think of other situations? Sports. So spell that out just a little bit. I'm not hiding the ball, but.
So like football, having women in football with men, you would have differences.
Okay, is there pushback on that though?
I think there is, yeah.
Yeah, what's the pushback?
Just like the capability for injuries.
Oh, sure. I mean, particularly if you're talking about women who are smaller and might get bulldozed, but
Physiological differences.
right, but also I'm going to get bulldozed if I step onto a football field.
Like there's instances where women can compete in men's football.
Okay.
I've seen it where they're the kicker or something, or like it's kind of like what Ginsburg was saying about how like some women want the challenge of Army or BMI.
Right, right. So not all women, perhaps not most women, most men are not going to be able to play football successfully and survive to tell the tale. Again, I would not. So, this is kind of Scalia's point, this doesn't have to be right for every single person. At the same time, Ginsburg's response is, well, sure, but that doesn't mean that everybody should not get the exact same opportunity. And so if you're a woman who can play football and can hang with the guys on the field, then why shouldn't you have that opportunity? At the same time, we have men's and women's track and field, men's and women's lacrosse. Does that convey any sort of inferiority, or is that a problem?
I think we're expanding the conversation to larger, to more sports outside of.
Sure.
You have the notion of separate but equal. If you think of men's and women's soccer teams.
Okay.
We've seen over the last few years, finally this battle for equal pay. So those
Yeah.
were both
Yeah.
separate teams, but they were never equal in terms of attendance, in terms of funding,
Mm-hmm.
in terms of their personal salaries. So
Mm-hmm.
that is going against the separate, is showing in that situation that it can't be equal. It could be equal.
Okay.
It's not historically been.
Okay.
because the matter of who is considered inferior. So you have
Yeah.
And so those cannot be equal unless they are awarded the same resources.
Okay, so this is kind of a hybrid of the equality litigation leading up to Brown versus Board of Education, but also this recognition that there are still some inherent physiological differences between men and women. By the way, I take everything on board that you just said. There have been positive experiences in this vein when we think about, for instance, professional women's tennis. Women's tennis for a long time was way more exciting than men's tennis, thanks to the Williams sisters who advocated for equal pay. So we can think about a lot of complex scenarios in this regard. Other thoughts on whether separate can be equal?
Well, I think the women's soccer example brought up an interesting idea for me, which is,
Sure.
is it equal access or is it equal
Okay.
outcomes? Because that completely changes the conversation.
Okay, all right. So this goes into, I think, a debate that is at least just beneath the surface between Justice Ginsburg and Justice Scalia. Are we talking about equal inputs, equal opportunity? Are we talking about equal outcomes? How do they understand it? How do they understand these questions of equal opportunity versus equal outcome? Yeah.
I think Ginsburg was arguing that no matter what inputs you put into it, unless they were allowed to go to VMI, you would never be able to get the same outputs. Because even if you had the same funding and even expanded the curriculum to have like hard sciences and engineering and things like that, you would never be able to go back to that alumni network that VMI had.
Okay, this was, my students are great about this, anticipating exactly the next question that I want to ask. So, VMI says, look, we have this array of opportunities for public education in Virginia. There is VMI. If women want access to something like VMI, let's keep VMI as VMI, but create opportunities for women. And what was the alternative that the Commonwealth of Virginia proposed?
They started a women's program at Mary Baldwin.
Right, which is just up the road in Stanton here. And you were starting to tell me why the Supreme Court said, yeah, that's not actually going to get to equality. Separation, sure, but why was the women's alternative at Mary Baldwin never going to be sufficient to truly create equality of opportunity?
Well, the initial conditions also weren't as good. Like Ginsburg pointed out, the SAT scores were lower at Mary Baldwin.
Right.
And they didn't have, they had liberal arts education, but they didn't have as many offerings. But then another thing she said is even if all of that was sort of rectified, because VMI has like 150-year history in this alumni network,
Right.
there's no prestige that you could add to Mary Baldwin that would equal that of VMI after.
Exactly right. Even if we are talking about equal funding, even if students coming in had same incoming credentials, so on and so forth, there is that intangible factor of the alumni network. You have that almost 2-century tradition of VMI. And, I mean, obviously there aren't 200-year-old alums, but you have this network that has endured for that amount of time. Absolutely right. I want to direct you to page 764 in the reading. And this gets to one of the fundamental problems in constitutional law when we are thinking about classifications based on race, based on gender, things that are inherently suspect classifications, as the Supreme Court will often talk about it. And these are classifications that have a history of discriminatory intent. So we've spent a fair amount of time talking about how not every gender classification is going to reflect a discriminatory intent on the part of the government. For example, maintaining separate men's and women's bathrooms. That does not show that the government views women as inferior to men. But historically, most gender classifications, most racial classifications do bespeak that kind of discriminatory intent. And so the Supreme Court has said we are especially skeptical of those classifications. Now, talk in constitutional law about different levels of scrutiny. Racial classifications are subject to the most exacting scrutiny, if you will, strict scrutiny. It's going to have to be justified by a compelling governmental interest. Essentially, there's no other way to accomplish the government's objective without a racial classification. That is exceedingly demanding. And again, it is born of the experience that in this country, most racial classifications were inherently invidious. They bespoke this discriminatory intent. It's a little more complicated, as the court tells us, when it gets to gender classifications. They're subject to what is often called intermediate scrutiny. Justice Ginsburg always spoke with a bit of a smile when she would talk about this opinion, and she would say, notice that the terms intermediate scrutiny appear nowhere. She didn't really believe in that. She thought that most gender classifications were pretty much as invidious as racial discrimination or as racial classifications. And so she says that gender classifications have to satisfy what? What does she say? Yeah.
Important governmental objectives and the discrimination has to be substantially related within the group.
Yes, so that is the intermediate scrutiny test, and then she adds another layer to it, which is that any sort of gender classification has got to be subject to, I saw a hand in the back.
Exceedingly persuasive justification.
Yes, an exceedingly persuasive justification. Chief Justice Rehnquist concurs, and he says, look, which is to say that if we flip over to the Rehnquist concurrence, notice it says concurring in the judgment. If you see concurring, that just means I'm fully on board with what the majority wrote, but I have some additional thoughts. When you see concurring in the judgment, that means I'm on board with the bottom line result, but I don't agree with the reasoning. And so what Chief Justice Rehnquist is saying here is, I see what you're doing, Justice Ginsburg. You're trying to raise the bar, and I'm not on board with that. I think that we should keep gender classifications at a true intermediate level of scrutiny, but she's pushing the envelope a little bit, and she is getting these gender classifications almost on par with racial classifications. Okay, so I was back to 764. When we are dealing with suspect classifications, like racial classifications, like gender classifications, the burden is on the government to justify why it needs to do that. And Justice Ginsburg is implicitly okay with this diversity rationale, but she says, VMI, you've given away the game. Because she says, look, this is the first full paragraph. She says, this is the very, very last sentence of that first full paragraph. A tenable justification must describe actual state purposes, not rationalizations for actions, in fact, differently grounded. In other words, VMI has just made this up. They simply want to maintain an all-male institution, and they're jury-rigging a justification after the fact. And she says, for purposes of heightened scrutiny, that is not going to pass muster. Now, that is going to be perfectly fine outside the context of suspect classifications. For instance, when you think about how the government sets tax brackets, there is no reason to think that there is a history of discrimination at work, and so the government gets a huge amount of latitude. This is rational basis review. That's going to be most economic legislation, for instance. But when these classifications are being drawn along historically suspect lines, then the test is, okay, what was your real reason? Don't lie to us, VMI, and if the Supreme Court smells a rat, they're going to call it out. No pun intended, because rats are what cadets are called at VMI, what they call themselves. This is not an external moniker that's imposed. All right, so with that in mind, how to realize this promise of equality? Should Virginia have been given more latitude? Or was the Supreme Court right to side with the federal government in their suit against Virginia.
I just want to have a question about
Sure.
this argument. I guess she says, I think this is right, in myriad respects other than military training, B-Will does not qualify as BMI's equal. If we're dealing with, like, say, or I guess, and the fact that, since this is a Supreme Court decision, it's applied to other places in the country after we think, if we're dealing with, like, I guess, if the suit happened to be brought against an institution a different institution, hypothetically, that was founded in a different state
Yeah.
last year or something.
Yeah. Yeah.
And it wouldn't have, and maybe it's founded with the same, I guess, principles, techniques, like this rattling thing that
Yeah.
does, founded last year in a different place. How is this argument about we will not qualifying as BMI's equal or this other institution, how does that change?
Yeah, this is a fascinating question about the way that precedent works. What is binding about this decision and what is merely persuasive in a different case. And it gets into some of these eternal questions that we are still grappling with and that courts and scholars don't even agree on to this day about what happens when a Supreme Court makes a pronouncement that separate cannot be equal in the sphere of public education, at least in the context of race. What does it mean when the Supreme Court decides VMI? And it essentially says that separate cannot be equal when there is a gender classification of this nature. Has the Supreme Court decided this issue for everybody, even people who did not participate in this lawsuit? Or do other constitutional actors at the federal level, at the state level, at the very local level, get to decide some of these questions? This is what's known as the debate between departmentalism, that each department, if you will, each separate branch of government gets to make its own constitutional interpretation, as opposed to judicial supremacy, this view that the court is there to interpret the Constitution, that it's supposed to smooth over the rough edges, that it gives us the law, and that becomes not just a gloss on or an interpretation of the law, but in many ways that is the law. That's an inherent tension that we still live with, and it has all sorts of ramifications when we think about challenges to governmental action. There were a lot of challenges early on in President Trump's administration to various policies, including the so-called Muslim ban, the travel ban, and individual federal judges were saying, this is unconstitutional, not just as to these people in front of me, but as to literally everybody in the entire United States. And it spawned a whole host of scholarship about whether that is actually within the purview of a federal judge's power. So these questions are ones that we live with. Now, the short answer in this context is that the VMI case has become the principal statement of gender equality ideas and how the Equal Protection Clause applies to gender classifications, including Justice Ginsburg's ratcheting up of this standard. That is to say that gender classifications need to be based on an exceedingly persuasive justification. I've got only a few minutes left with you, so I want to talk about some of the aftermath. So the Supreme Court decides this in the summer of 1996. What's the vote, by the way? 7-1. Okay, so Scalia's our one dissenter. Why are there not 9?
Because Thomas recused himself because his son was attending VMI.
Correct, exactly right. Justice Thomas's son Jamal had attended VMI, so he said, all right, I have to recuse. All right, so it's a 7-1 decision. VMI, to its credit, did not drag its heels. The board met and, again, by that 5-4 vote, decided that it was going to remain a public institution, and it committed itself immediately to retrofitting barracks to accommodate women, to figuring out how VMI was indeed going to be an inclusive place for women. And they started accepting applications that fall in 1996. And I'm going to date myself here. That was my senior year of college. Or excuse me, of high school. That was my senior year of high school. And one of my high school classmates was among the first class of women to matriculate at VMI. And when she was admitted, when she decided to go, I remember saying, I pity the idiot who thinks that she doesn't belong there, because she will wipe the floor with them eventually. Now, this was Rat Week, where the adversative method is in full display. This was a very famous photograph in the Washington Post during that week in August of 1997. And there was some consternation about how this was all going to shake out. But I think that the experience of the last generation has shown that VMI is a much more robust place because of the inclusion of women. And on the 20th anniversary of the decision, it came down to Lexington. She came to the law school, and this was before I got here, but evidently it was just a marvelous visit. And she spoke at VMI on the occasion of the anniversary. The then dean of the law school facilitated a conversation with her, and it was pretty remarkable, because then she went and toured barracks, including the barracks that had been retrofitted immediately after the decision had come down.